Your second property could quietly become one of the biggest financial liabilities connected to your retirement, and most Americans never discover the risk until a medical emergency suddenly forces the issue into the open. Before you make another financial decision today, take a moment to understand how this system actually works. Not because somebody is trying to frighten you, not because this is designed to sound dramatic, because federal Medicaid regulations already influence how secondary real estate is treated in long term care planning, and millions of retirees across the country still do not fully understand the consequences until their options have already become limited. This is not internet speculation. It is not a hidden loophole buried in some obscure legal theory. It is an established federal framework that has existed for decades and is enforced through every state Medicaid agency in America. These rules determine which assets count toward eligibility, which assets may receive protection, and which assets can later become targets for estate recovery after death. Yet most property owning retirees go through life believing their second home, rental property, or inherited land will automatically pass to the next generation without major complications. For many families, that assumption turns out to be dangerously incomplete. Here is the situation that catches retirees off guard every single year. You worked for decades. You paid taxes. You contributed to retirement accounts. You slowly built stability piece by piece while sacrificing vacations, free time, and financial comfort along the way. Eventually, you purchased a second property. Maybe it was a quiet lake house where your children spent summers fishing off the dock. Maybe it was a small mountain cabin where you planned to spend retirement watching the seasons change. Maybe it was a modest rental duplex that gradually became your most dependable source of supplemental income. You probably viewed that property as security, as legacy, as proof that your lifetime of work created something meaningful that could eventually help your family. But Medicaid systems often view that same property in a completely different way. In many states, any property that is not your primary residence may be treated as a countable asset when determining eligibility for Medicaid long-term care benefits. That means vacation homes, rental properties, inherited parcels of land, investment property, recreational property, and additional residences may all be included in the financial review process. And here's where the situation becomes serious. When families first learn about these rules, many people react emotionally and immediately attempt to transfer the property to children or relatives. Unfortunately, if those transfers occur during Medicaid's 5-year look-back period, the result can be a financial penalty that delays eligibility for long-term care assistance. In other words, families may still face massive nursing home expenses while simultaneously losing control over the property they were trying to protect in the first place. This is why advanced planning matters so much. The entire issue begins with how Medicaid classifies property. Federal Medicaid regulations draw a sharp distinction between a primary residence and nearly every other category of real estate you own. Your primary home may qualify for important protections under Medicaid eligibility rules if specific conditions are satisfied. In many situations, applicants are allowed to keep ownership of their primary residence while receiving benefits, subject to state-specific equity limits and legal requirements. But secondary properties are usually treated differently. Vacation homes, rental units, investment property, undeveloped land, inherited acreage, and timeshares with equity are often classified as countable resources. To Medicaid eligibility reviewers, the emotional meaning attached to the property is generally irrelevant. The review focuses on ownership, available equity, market value, transfer history, and legal structure. That surprises many retirees because nobody explains these distinctions during normal retirement conversations. Most people assume that if they worked hard to acquire a second property, the property will naturally remain within the family forever. But long-term care expenses can change that outcome extremely quickly, and those expenses continue climbing every year. In many regions of the United States, skilled nursing care now costs well above $10,000 per month. Some facilities charge considerably more depending on the level of care required and the cost of living in the area. A lengthy nursing home stay can drain retirement accounts, investment portfolios, savings, and property equity at an astonishing pace. That is why Medicaid planning exists. But many families misunderstand the system until a crisis suddenly forces them to learn everything under pressure. One of the most misunderstood areas involves the primary residence exemption. Many Americans assume their home is automatically protected under every circumstance. The reality is more complicated. In many states, applicants are required to indicate that they intend to return to their primary residence. This is commonly known as the intent to return provision. Depending on the state, that declaration may involve a signed statement, application checkbox, affidavit, or written form submitted during the Medicaid application process. When the residence qualifies properly, it may remain exempt for eligibility purposes during the applicant's lifetime. But confusion during the application process can create problems families never anticipated. Loved ones sometimes make statements about the severity of a patient's medical condition without realizing how those statements may influence eligibility evaluations or documentation requirements. This is one reason experienced elder law attorneys emphasize careful preparation before any Medicaid application is filed. Secondary property does not usually receive that same level of protection. And that brings us directly to one of the biggest financial traps connected to Medicaid planning: the 5-year look-back period. When families first discover that second homes may affect Medicaid eligibility, the immediate instinct is often simple: transfer the property, sign a deed, move ownership to the children, problem solved. Except in many cases, that reaction creates even larger financial consequences. Medicaid agencies review financial activity during the 60 months leading up to a long-term care application. This review process is known as the 5-year look-back period. During that window, states may examine bank statements, property records, gifts, transfers, asset movements, and financial transactions. If assets were transferred for less than fair market value, the transfer may trigger a penalty period. Rather than immediately qualifying for Medicaid assistance, the applicant may become temporarily ineligible for certain long-term care benefits. The calculation varies by state, but generally the uncompensated value of the transferred asset is divided by a state-specific monthly nursing home cost figure. The result becomes the penalty duration. During that period, Medicaid may refuse to pay nursing home expenses. Consider a simplified example. A retired couple owns a primary home and a vacation cabin worth approximately $200,000. Later, one spouse requires nursing care costing roughly $12,000 per month. Several months before applying for Medicaid, the family transfers the cabin to an adult child for a symbolic amount. During the application review, the state identifies the transfer through public property records. A penalty period is then calculated based on the uncompensated transfer amount. That delay may leave the family responsible for massive private pay care costs before Medicaid assistance begins. At the same time, ownership of the property has already changed. The family loses control over the asset while still facing overwhelming expenses. This is why rushed transfers completed without qualified legal guidance often create more damage instead of solving the original problem. State law makes everything even more complicated. Federal Medicaid law establishes the general framework, but every state administers its own Medicaid program differently. Procedures, recovery practices, planning opportunities, exemptions, and eligibility interpretations vary considerably depending on location. Florida is known for strong homestead protections involving primary residences, yet secondary properties may still count against Medicaid eligibility calculations. California modified portions of its Medi-Cal asset structure in recent years, creating broader eligibility standards in some situations. However, estate recovery procedures can still apply under specific conditions. Massachusetts has historically maintained aggressive estate recovery policies involving certain non-probate interests. Texas generally operates under a narrower recovery framework focused primarily on probate assets. Ohio follows federal home equity standards while also maintaining estate recovery procedures after death. The important point is simple: no two states operate exactly the same way. That is why generic advice from internet videos, online forums, or social media clips can become extremely dangerous. Planning strategies that work effectively in one state may create serious legal or tax problems somewhere else. And many retirees never realize that Medicaid involves two completely separate financial stages. The first stage is eligibility during life. The second stage is estate recovery after death. Even if someone qualifies successfully for Medicaid benefits during life, states are generally required under federal law to operate Medicaid estate recovery programs. These programs attempt to recover certain long term care expenses from assets remaining in the recipient's estate after death. This is where secondary real estate often becomes especially vulnerable. Vacation homes, rental properties, inherited land, and undeveloped acreage are relatively easy for states to identify and value. If those assets remain legally owned by the Medicaid recipient at death, recovery claims may apply depending on state law and probate structure. Some states even maintain broader recovery authority involving selected non probate arrangements. This is another reason proactive planning matters. Many families mistakenly believe that once Medicaid eligibility is approved, the issue is over forever. But estate recovery can become an entirely separate challenge later. Fortunately, legitimate planning strategies do exist. One commonly discussed approach involves a Medicaid Asset Protection Trust. This type of trust is generally irrevocable and must be drafted carefully by a qualified elder law attorney. When property is transferred properly into the trust becomes the legal owner rather than the individual. However, timing remains critical because the 5-year look-back period still applies. If the transfer occurs far enough before Medicaid is needed, the property may no longer affect eligibility calculations in the same way. Depending on the trust structure, families may still retain limited usage rights connected to the property. Another planning strategy involves selling secondary property at legitimate fair market value and repositioning the proceeds into categories that may receive protection under Medicaid rules. That could involve improving a primary residence, funding approved burial arrangements, paying down certain obligations, or using other lawful planning tools. The key detail is proper structure. Improper transfers, undocumented transactions, or rushed decisions can create major complications later. A third option some retirees explore is long-term care insurance. For individuals who begin planning early enough and qualify medically, long-term care insurance or hybrid insurance products may help offset future nursing home expenses. If care costs are covered through insurance, families may avoid needing to liquidate secondary property entirely. Of course, premiums can be expensive, and not every applicant qualifies. Still, for the right retiree at the right age, insurance can become a valuable layer within a broader protection strategy. Unfortunately, many families attempt planning alone. That is where expensive mistakes usually happen. One common mistake involves outright gifting. Parents transfer property to children believing the transfer guarantees protection. But besides Medicaid penalties, the property may now become vulnerable to the child's financial risks. That includes lawsuits, divorce proceedings, creditor claims, bankruptcies, or business liabilities. Another mistake involves adding children directly onto deeds. Families often assume this automatically simplifies inheritance planning, but it may create tax complications involving capital gains and stepped-up basis rules. In some cases, the tax impact alone becomes extraordinarily expensive. Perhaps the most damaging mistake is the last-minute transfer executed immediately after a diagnosis. Families panic. Documents get signed quickly. No attorney reviews the strategy carefully. Nobody fully understands the 5-year look-back system. Then later, the family discovers that the transfer triggered penalties while simultaneously creating legal and financial complications. This is why timing matters so much in Medicaid planning. Families who begin reviewing their options years earlier usually maintain far more flexibility. Waiting until after a medical emergency often eliminates many of the most effective planning opportunities. So, what should retirees actually do? First, avoid panic. Second, get accurate information from qualified professionals. Within the next month, property-owning retirees should strongly consider scheduling a consultation with an experienced elder law attorney in their state. Not a general attorney, not a random online form company. A professional who specifically handles Medicaid planning, estate recovery issues, asset protection strategies, and long-term care law. Before the consultation, gather detailed financial records. Prepare a list of every property you own. Include estimated market values, mortgage balances, ownership structures, rental income information, and recent financial statements. Ask direct questions. How does your state treat secondary property under Medicaid rules? Does your state apply expanded estate recovery authority? Would a Medicaid asset protection trust make sense for your situation? What tax consequences could result from various planning approaches? How does the 5 year look back period apply to your assets? And most importantly, how much planning time remains before your options become limited? If planning documents are eventually created, make sure every detail is handled correctly. An unsigned trust may provide no protection. An improperly recorded deed may create confusion instead of security. A beneficiary designation that conflicts with the estate plan can undermine the entire strategy. Details matter enormously because long term care costs are no longer theoretical risks. Americans are living longer than previous generations. Medical advances continue extending life expectancy. And extended nursing care has become one of the largest financial threats facing retirement planning today. For many families, secondary real estate represents decades of sacrifice, memories, and disciplined saving. Without proper planning, those assets may become vulnerable to care expenses, eligibility complications, or estate recovery claims. But preparation changes the outcome dramatically. Families who understand the rules years before they need Medicaid generally have more flexibility, more legal options, and better financial outcomes than families forced into rushed decisions during a crisis. That is the real message here, not panic, preparation. Because the planning window begins now, not after a diagnosis. The sooner retirees understand how Medicaid rules interact with secondary real estate, the more opportunities they may have to protect family assets responsibly and legally. And while no single strategy works for every family, informed planning with qualified legal guidance can help retirees avoid many of the most financially destructive mistakes. This content is intended solely for educational and informational purposes. It should not be interpreted as legal advice, financial advice, tax advice, or Medicaid planning guidance for any specific individual situation. Medicaid eligibility standards, exemption limits, estate recovery procedures, and look back rules vary by state and may change over time. Always consult a licensed elder law attorney or qualified financial professional in your jurisdiction before making decisions regarding trusts, property transfers, estate planning, or Medicaid applications.